People who are working in this area are trying very hard to find new ways of preventing the risk of harm to children when we're dealing with these kinds of access issues. A few years ago, there was a conference called the Wingspread Conference, where there were invited domestic violence scholars and invited child custody experts and court professionals to this conference. There were attempts to get both groups to use a common vocabulary. I'm afraid these attempts did not succeed. There was a whole issue about whether or not domestic violence cases are all the same, or whether there's different motivation for domestic violence cases that would need different kinds of interventions, and that some of them might not be dangerous for the batterers. Well, there has been a call for research at the end of that conference, because there was total disagreement on whether or not there were different patterns or different motivation or even different treatment. The violence that's used for coercive control seems to be across the board in all of these areas, even in those where violence is used as a resistance or self-defense, or it's driven by conflict, or it's separation-instigated violence, or it's violence stemming from severe mental illness. Well, there's no question, if somebody has severe mental illness and is using violence, that children need to be protected, and women need to be protected from that. But there is really no such thing as separation-instigated violence. What we see in those cases where somebody may not have used physical abuse before the separation and then starts to use it is that there was a lot of psychological power and control being used throughout the relationship, and it just jumped another step when the separation occurred. Violence driven by conflict is the same, maybe different things going on, but in a domestic violence relationship, there's always the possibility that anything that shakes up the environment is going to cause a battering incident, and certainly conflict would do that. Leslie Droz, Dr. Leslie Droz, a psychologist in California, and editor of the Journal of Child Custody, has looked at risk factors that when somebody's doing a custody evaluation, you need to take into account. For example, some of the factors she's talked about: the history of previous violence. Is there a pattern of coercive control? Not just physical violence, but control. Is there frequency and severity that increases over time? Was the child exposed to or actually experienced abuse? Is there substance abuse in the family? Is there a major mental disorder for the parents, for the children? How about developmental antecedents in childhood for either party? And what about threat assessment factors? Indirect or direct threats made by either party, obsessive following, stalking, surveillance, texting, we call it cyber texting now, calling on the telephone, making sure he knows where she is at all times, possession of weapons. These are all very high risk factors. So what do we do if we find these high risk factors? Well, if we're involved in developing a parenting plan or commenting on a parenting plan, be aware that there are different continuum of parenting arrangements. We can go from co-parenting, which is the traditional presumption in the law, but that's for parents who cooperate closely, and it requires mutual trust and communication, which we don't have in most domestic violence relationships. It could also be parallel parenting, where there's minimal contact with each of the parents, but there's a detailed and a structured plan. This takes work to put together. And each parent contributes positively, even though they may be acrimonious with each other. And they may be positive towards the child, and they are willing to communicate with the other parent. The third possibility is supervised visitation transfer. That is, sometimes the transfer of children back and forth is problematic, and at those times there may need to be supervision. Perhaps the transfer should take place at the police station locally, or at a 24-hour restaurant, if you will. Supervised visitation is the fourth possibility in a parenting arrangement. For high-risk parent-child needs, they should have a safety plan, but if the child will gain from the contact, then perhaps the supervised visitation may be the best. This helps batterers who haven't been involved or engaged in parenting also learn some of the proper parenting techniques. And then the last, which unfortunately isn't recommended enough, is no contact or access for a certain period of time. If there is not a meaningful relationship at this time, and there's a possibility of high risk if the child is in contact with the other parent, then there should be no contact or access for a period of time. The child should be in treatment, and of course the batterer should also be in treatment before the relationship is resumed. Otherwise, the relationship will never be able to become meaningful. Janet Johnston, another researcher in the area of child custody, has talked about 5 priorities in her schema. She says that we have it backwards when we say that priority 1 is to allow the child access to both parents. She says no, the first priority has to be to protect the child. Priority 2 is to protect the safety and well-being of the victim parent, and to also permit the victim parent to make sole decisions so that she does not get held hostage by a batterer who refuses to cooperate. Priority 3 is to respect the right of adult victims to direct their own lives. Sometimes, in cases where one party is asking for removal to another place, usually the victim, the court orders them to stay put. That is not helpful. Stay in the same county may be very dangerous for both the victim and for the child, and maybe also for the battery. So we need to really stop that and learn to respect the right of adult people to direct their own lives. Priority 4, hold the perpetrators accountable for their abusive behavior. If they continue to violate the restraining order or continue to violate any of what has been put in place, any of the plans, then they need to be held responsible for it. And finally, the 5th priority is where if all the other 4 are met, then we can allow the child access to the batterer. Some people believe that maybe it's time to let children have legal rights. We know that children in the dependency courts, the attorneys who work with these children, have started fighting for legal rights for children, to give them legal standing in court, give them their own attorney. There's a difference between a guardian ad litem who fights for the child's best wishes and a child's own attorney who fights for the child's, the guardian fights for the child's best interests, and the legal attorney fights for the child's best wishes, what the child really wants. Only 2 states have earned a grade of A+ in allowing children legal standing. 29 states were given grades of C or lower, and the lowest grade of F was given to 7 states, and Florida was one of them. We do not protect our children here. And sometimes the psychologist is involved in it. So we need to really look at how best to protect our children, especially in cases where domestic violence or even sexual abuse of the child has been reported. I might mention that research has shown that some studies have shown that somewhere around 50 to 60% of all children in domestic violence homes have had some form of either sexual or physical abuse. Not only the psychological abuse, which we know occurs when a child is in a home where fathers are abusing their mothers. So let's move on. What can we do once somebody has been involved in a domestic violence relationship and then wants to come to one of us for therapy? Well, the state of Florida and many other places nationally are looking at making sure all of our services that we provide are what we call trauma-informed services. That is, a trauma-informed service has a culture where all people who are service delivery persons understand the prevalence of trauma, the impact of trauma, and the complex paths leading to healing and to recovery. Trauma-informed services specifically avoid re-traumatizing both those who seek their services and those who are on their staff. Trauma-informed services puts safety first and commits to do no harm. There's several books that are now out talking about trauma-informed services. One of the books that I've been reading lately and gotten some interesting information I'm sharing with you comes from Harris and Fallett, calling Creating a Culture Shift. That was published in 2001, and it's an interesting book. Title of it is Using Trauma Theory to Design Service Systems, New Directions for Mental Health Services. And I took from the book five specific areas where we want to make sure that we are either up to date in providing the culture or that we're either up to date in providing a trauma-informed services, or if we have to do a culture shift in either our own offices, which is easier to do than in the whole agency that we work in. The first is safety, and that's just paramount. I mean, if we cannot ensure the physical and emotional safety of the people who come to us, then they're not going to come. Or if they do come, they're not going to come feeling comfortable. So we have to look at to what extent do the programs, activities, and settings ensure the physical and emotional safety of persons who are served, and if you work in an agency, the staff that work there with you. How should services be modified to ensure safety more effectively and consistently? And here are some of the areas that you might want to look at. You might want to look at, how secure is the area where the services are delivered. If you're late at night and it's a scary neighborhood, do you have security guards? Do you have locks on the doors? We had some of our students who were working in a forensic setting where people who came to the setting were violent, and we never knew when they would act out. Well, of course they are in a secure setting, but if we're putting staff to go into those units, do we have guards around or somebody around, some kind of security in case there is an incident? When we first started sending our students there were security people. But then they moved them off the floors and put them in one place, and it was insufficient. There were more outbreaks of violence, and we said we can't put students there. You may feel the same way if you're working in a place like that. If there isn't security, how can you be comfortable in working with people, especially if they're going to talk about violence? It's going to make us uncomfortable. It has to. What signs are there? You know, is where you work welcoming to people? You know, do you have your office fixed in such a way that people feel comfortable there? I remember talking to judges a while ago where I suggested that many women find a judge's courtroom, the male judge's courtroom, but sometimes the women as well, as a sterile men's club. Put a plant up, a picture up, do something to make it a little bit more comfortable. I keep plants in my office, as you can see, and take them out, especially put them in different places, depending upon who I'm seeing here, because I want everybody to feel comfortable when they come in. Are staff attentive to consumer discomfort or uneasiness? Do you take clues? You might think you're doing great, but do you take clues from the people who you see? Is there sufficient personal space for individual consumers? Is there a welcoming chair to sit outside if you're not ready for them? How are consumers greeted? Is the person who sits in the front, if you work in an agency, pleasant? Or do they just sit there and not greet the people who come in?